Okay, so thanks everyone for joining us. My name is Milwaukee Schwartz, and I'm the Coastal Commission's Public Information Officer, and I also manage our environmental justice work. And I'm here today with staffers Sumi Selvaraj, who you just heard, Amber Anastasia Roberts, Sarah Christie, and Michael Ng. And we're really excited to go over the Coastal Commission's environmental justice policy with everyone today. And we're going to start with the discussion, or we're going to start our discussion with a short presentation, very similar to the one that we gave at the March Commission meeting, where the policy was adopted. So there's a few webinar logistics. Everyone is automatically muted. If you have any questions during the presentation, please type them into the chat box and we'll answer them at the end of the session to the best of our ability. So we're going to start today's presentation with a brief discussion about why the Commission adopted an EJ policy. Then we'll talk about the policy itself and provide examples of how environmental justice is appearing in our work. So for more than 40 years, this agency has worked to protect the coast and everyone's right to enjoy it. And we do this by regulating development proposals along the coast. In other words, the Commission can approve, modify, or deny new proposals, and we work with local governments to draft local coastal plans that reflect Coastal Act policies. And this new environmental justice policy will enable us to make progress on a promise to provide coastal protection and access for all people. If you want to learn more about the Commission's history and why our agency set out to develop an environmental justice policy, you can watch an earlier webinar on our website that we recorded, or you can read our environmental justice story map, which is also on our website. So the concept of environmental justice emerged out of the civil rights movement to describe an application of civil rights and social justice to environmental contexts. Beginning in 1999, California passed a series of bills advancing the concepts of environmental justice, which sought to correct long-standing inequities that have disproportionately burdened lower-income communities and communities of color, or denied equal access to social, economic, and public health benefits associated with environmental protection and access to natural resources. Our policy is the result of one of those bills, Assembly Bill 2616, by Assemblywoman Autumn Burke, which was signed by Governor Brown in 2016. This bill amended the Coastal Act by adding Public Resources Code Section 30013, which cross-references existing environmental justice and civil rights law, and required the governor to appoint an environmental justice commissioner. And that commissioner is currently Effie Turnbull Sanders. It also added Public Resources Code Section 30604H, which reads, when acting on a coastal development permit, the issuing agency or the commission on appeal may consider environmental justice or the equitable distribution of environmental benefits throughout the state. So the goal of the Commission's environmental justice policy is to provide guidance for commissioners, staff, and the public on how the agency will implement its authority on environmental justice. We decided to raise the bar in order to ensure public confidence in the agency's commitment to coastal equity, and we're taking additional steps to integrate environmental justice, equality, and social equity within the agency and into the foundation of the coastal program and the Commission's operations. So one of the first things that we did was form an environmental justice team across the agency in every major department, which spent months meeting with stakeholders across the state to better understand their perspectives and hear what they wanted in a policy. Comments and feedback were organized into broad categories, such as barriers to access, tribal concerns, energy, agency outreach, and engagement. We incorporated that input into multiple draft policies, including a version released in Spanish and English, to invite as much public comment as possible. In March 2019, the Commission unanimously approved a final policy at the African American Museum in Los Angeles. So before we move on to the details of what's in the policy, I just wanted to give everyone a broad overview of what it means to integrate principles of environmental justice and social and racial equity throughout our agency. So the environmental justice policy is really the leading effort of this larger framework. The policy will provide both the public and the Commission with information about how the agency will conduct the public's business, make decisions, and ensure equitable procedural access for all. A team of Coastal Commission staff has also been drafting a racial equity action plan through their work with the Government Alliance on Race and Equity, GARE, which is a program that builds the capacity of government to advance racial equity. Our racial equity action plan will inform our internal policies, such as those related to recruitment, hiring, retention, and promotion. Lastly, we're also in the process of updating our 5-year strategic plan, which will include a new chapter on environmental justice. The strategic plan will be the document that creates ongoing public accountability by identifying the specific tasks necessary to successfully implement both the environmental justice policy and the equity action plan. So Amber will now briefly explain the policy's guiding principles and the implementation section. And we encourage everyone, however, to read through the entire policy itself, which provides additional context and detail. A copy of the policy is available in the webinar handouts tab.
Thank you, Nilaki. My name is Amber Anastasia Roberts, and I am a NOAA Coastal Management Fellow here at the Commission. I am now going to briefly discuss the contents of the policy. The policy begins with an introduction and a broad environmental justice policy statement that lays the foundation for the Commission to consider environmental justice principles consistent with Coastal Act policies during the planning, decision-making, and implementation of agency actions, programs, policies, and activities. The next section of the policy is a statement of environmental justice principles, which includes a series of commitments for each of the following topics: respecting tribal concerns, meaningful engagement, coastal access, housing, local government, participation in the process, accountability and transparency, climate change, and habitat and public health. These are meant to inform not only our analysis of potential impacts, but also our process of how our staff engages with interested stakeholders and make information accessible to a broader audience. Respecting tribal concerns. In addition to the requirements of the Commission's formal tribal notification and consultation policy, the Commission will work collaboratively with tribes to better understand the significance of local and regional cultural concerns. This includes the application of traditional ecological knowledge, as well as access to and protection of areas of cultural significance, ethnobotanical resources, traditional fishing and gathering areas, and sacred sites. Tribal members who come to Commission meetings will be afforded the same level of respect given to elected representatives and will be called up to comment first on agenda items. Meaningful engagement. Because of the historic underrepresentation of environmental justice groups and underserved communities in coastal land use planning and permitting decisions, staff will make additional efforts to inform these communities about projects with environmental justice findings. We plan to augment outreach with non-traditional communication methods such as flyers or community meetings, for example. Coastal access. The Commission reaffirms its commitment to identifying and eliminating barriers to coastal access and considers preserving and providing for lower-cost recreational facilities an environmental justice imperative. This includes recreational opportunities such as parks, trails, surf spots, beach barbecue and fire pits, etc. We also now have a policy of no net loss of lower-cost facilities. And where a local government fails to consider environmental justice when evaluating a proposed development that has the potential to adversely or disproportionately affect a historical disadvantaged group's ability to reach and enjoy the coast, that failure may be the basis for an appeal to the Coastal Commission. Similarly, where a local coastal program includes policies that implement environmental justice principles, a local government's failure to consider those principles may also be the basis of an appeal to the Coastal Commission. Housing. Although the legislature removed the Coastal Act mandate to protect and provide affordable housing in 1982, the Commission still has the authority to encourage affordable housing. The policy states that the Commission will increase these efforts with project applicants, appellants, and local governments by analyzing the cumulative impacts of incremental housing stock loss, and by working with local government to adopt local coastal program policies that protect affordable housing. We are also going to continue to seek legislative action to regain the Commission's previous authority. If it is reasonably alleged that a proposed project or a permit on appeal is or would be in violation of another state or federal law, the Commission will utilize its discretion to contact the appropriate agency to resolve the issue. Local government. The Commission will strongly encourage local governments to amend their local coastal programs, port master plans, public works plans, and long-range development plans to address environmental justice issues. Staff will develop a list of best practices to help local government develop policies that reduce impacts on vulnerable communities resulting from new development. Regional transportation policies can also discourage communities from visiting the coast. The Commission will work with local governments and regional transit agencies on local coastal program policies to encourage public transportation options to the coast from inland areas and incorporate smart growth principles that include increased residential density so people can work and live in communities and reduce greenhouse gas emissions from vehicles traveled. Participation in the process. The Commission is committed to identifying and eliminating barriers to its public process in order to provide a more welcoming, understandable, and respectful atmosphere for those who may be intimidated or deterred from taking part in government proceedings. This includes making an effort to schedule items with significant environmental justice implications close to affected communities, and at locations and times accessible to those who work during the day or lack access to private vehicles when legal deadlines allow. Although during our monthly hearings we cannot guarantee a specific time when an item will be heard, we do have the ability to schedule something at the beginning of the day or at the end of the day, so people can have a better idea of what part of the day an item will be heard. We also commit to provide language translation services as needed and time extensions for translators. The Commission will not engage the services of private security or law enforcement unless a credible threat to public safety has been clearly demonstrated. Accountability and transparency. When evaluating projects, the Commission will consider whether and how a proposed development will positively or negatively affect underserved communities, and will be transparent in that analysis in staff reports and presentations. The Commission will make use of Cal EnviroScreen, US EPA EJ-Screen, US Census data, and similar tools and data to identify disadvantaged communities. And where consistent with the Coastal Act, the Commission will propose permit conditions to avoid or mitigate impacts to underserved communities. Staff will assess meaningful alternatives beyond mitigation measures to re-siting projects with negative environmental health impacts in disadvantaged communities to minimize or avoid adverse impacts. The Commission will also review claims of environmental justice that are used to advance issues that may have no positive environmental impact on surrounding communities. Climate change. Climate change and sea level rise hazards will have disproportionate impacts on communities with the least capacity to adapt and may exacerbate existing environmental injustices and cumulative impacts from other environmental hazards. For example, climate change impacts on coast and ocean resources disproportionately affect underserved communities, which may rely on public access for indigenous gathering activities, subsistence fishing, recreational opportunities, jobs, and other economic benefits of the coastal economy. Some sea level rise, coastal erosion, and climate adaptation measures, such as seawalls, may further reduce access to coastal recreation areas for all residents, particularly those living inland. The Commission will take this reality into consideration when analyzing the effectiveness and the impacts of sea level rise adaptation and mitigation measures, as well as implementation of these measures. Habitat and public health. The Commission's environmental justice policy will be implemented in a manner that is fully consistent with the standards in and furthers the goals of Chapter 3 of the Coastal Act and certified local coastal programs. In addition to the protection of coastal resources broadly, the Commission will work to ensure that low-income communities are not disproportionately affected by water contamination or overuse, or diminished environmental services. The Commission will also work with the relevant public agencies to consider project impacts to air quality and soil health in disadvantaged communities, which will affect the health and recreational benefits associated with coastal access for pollution-burdened communities. Now, Sumi will talk a little bit more about implementation.
Thank you, Amber. My name is Sumi Selvraj, and I'm a coastal analyst at the Commission. I'm now going to discuss how we have been implementing our environmental justice policy. At the request of stakeholders, staff included a lengthy implementation section in the policy. Much of this will also be added to the next strategic plan, which will provide the public with ongoing accountability and transparency. The staff's training and support section includes several commitments, including one to designate staff in every district office of the Coastal Commission who can be point of local contact for environmental justice groups and stakeholders. These staff members will provide more effective and personalized responses to issues and facilitate ongoing communication among staff and environmental justice communities. A list of current local staff contact can be found on our environmental justice webpage. The Coastal Development and Environmental Justice section includes a commitment to develop an internal checklist for staff to help analyze the existence of potential environmental justice impacts associated with a proposed project. Staff will identify environmental justice communities in the area and potential impacts of the project on those communities. Another commitment in this section is that analysis of environmental justice issues will be included in applicable staff reports and, when appropriate, propose mitigation measures. Excuse me, could you please mute yourself? Thank you. Sorry about that. And when appropriate, propose mitigation measures to avoid or fully mitigate identified impacts in a manner that is fully consistent with Chapter 3 or local coastal program policies. The public participation section includes commitments to make Commission meetings more geographically accessible, affordable, and inviting to underserved communities by adopting an annual meeting calendar that includes at least 3 Commission meetings per year in more inland areas accessible by public transit. To track and measure success, the Commission shall conduct a biannual public review on the effectiveness and progress of the policy and amend the policy as appropriate. I'm now going to share a few examples of how we have already addressed environmental justice in our work. As Noaki mentioned earlier, the Commission has been working on the formulation of this policy since 2016. During that time, environmental justice issues have been surfacing in our permitting, planning, and enforcement work, and the Commission is already beginning to broaden its efforts to address them. For example, environmental justice findings were used to strengthen staff recommendations in the 11 Lagunita case in August 2018. This enforcement order was for removal of an unpermitted seawall. The staff report pointed out that seawalls protect a small amount of private property at the direct expense of the public, which loses sandy beaches for low-cost recreation. The burdens of seawalls are disproportionately borne by low-income and minority communities who cannot afford to rent oceanfront houses. Similarly, in other enforcement orders and coastal development permits with coastal access issues that raise environmental justice concerns, staff is including environmental justice findings in the reports. Staff is also starting to address environmental justice concerns in local coastal programs, port master plans, and other planning updates when possible. For example, in November 2018, the Port of San Diego wanted to build a permanent event venue for the symphony at Embarcadero Marina Park South, which resulted in the permanent closure of park space available to the general public free of charge. As mitigation, the port and applicant agreed that the applicant would contribute funds for the expansion of Pepper Park in National City. In the public access and recreation findings for the amendment, staff included a discussion on the limited public access to waterfront recreation and lack of open space in National City, which was identified as a disadvantaged community using Cal EnviroScreen. We are also implementing on non-regulatory actions from our environmental justice policy. For example, the Commission revised language in its standard job postings to include the following specific statement. The California Coastal Commission values diversity at all levels of the organization and is committed to fostering an environment in which employees from a variety of backgrounds, cultures, and personal experiences are welcomed and can thrive. We believe the diversity of our employees and their unique ideas inspire innovative solutions to further our mission of protecting and enhancing California's coast and ocean for present and future generations. In a few weeks, we will be posting job announcements for positions in our environmental justice program to continue implementing our environmental justice policy. Now I'm going to hand it back to Noaki, who's going to wrap up our presentation.
Thanks, Amy. So we hope these examples have given you some ideas of how environmental justice will intersect with the Commission's work. Implementing coastal management through a focused environmental justice lens is something new and exciting in the agency's history, and we really want to make sure we get it right. In an effort to do so, we spent months reaching out to over 100 California Native American tribes, environmental justice groups, and individuals by email, phone, and in person to ask them one key question: what do you want to see in this policy? And the environmental justice community eloquently answered that question. And this environmental justice policy document is a result of all that collective wisdom and guidance. If you have any questions after the webinar, we encourage you to contact us or one of our district offices. And with that, we're going to open up the lines for discussion.
Thank you, Nawaki. Hi, everyone. If you have questions, please add them in the question box. Right now, I see one question from early on that asks, how well are the commissioners versed on the Coastal Commission's environmental justice policy? Nawaki, would you like to answer that one?
Sure. So, we had a series of commission meetings where we presented the policy at length to the commissioners. And we've had since then, some commissioners leave the agency and some new commissioners come. And, they have read through the policy, and we are planning on doing some sort of training with them sometime next year. And we are planning some staff training as well.
Thanks, Nawaki. It seems like we don't really have any other questions at the moment, but we will hang on for a few minutes to see if anyone wants to type any in or has any other questions.
And of course, if something occurs to you, afterwards, feel free to reach out to any of us, and we'd be more than happy to help.
Okay, I got one more question. Is there guidance forthcoming for translating the environmental justice policy into LCP updates or as sea level rise requirements? We have Madeline Cavallari from the Statewide Planning Unit. I believe she's on the line. Madeline, are you there?
Sorry, can you hear me?
Yes, we can hear you now.
Okay, great. Sorry, would you mind just rephrasing one or restating one more time for me?
Sure. I got a question that asked, is there guidance forthcoming for translating the environmental justice policy into LCP updates or sea level rise requirements?
I'm not sure that we are specifically thinking about a guidance in terms of sea level rise requirements, although I believe, and actually, I apologize. I think Nawaki might have a better handle in terms of, forthcoming guidance related to environmental justice.
Right. We are, planning on having some training for our staff in, I think, early next year for our entire staff. And we're actually kind of shaping that training right now. So, we probably will include some sort of sea level rise section. And then there is, as I think you heard, there is sort of a section in our policy on page 11 that touches on climate change.
Thank you, Nawaki and Madeline. The next question is, where can we find a copy of the policy? And as soon as you will appoint people to each district, could you and our staff contact. So you can find a copy of our policy online, and I've also included it in the handout section of this webinar. So you can also download it directly from this webinar. And following the webinar, we will send a link to the website and the policy in a follow-up email. The next question asks,
if you don't want to wait though, you can just go straight to our Coastal Commission homepage, and there's an environmental justice section in our page on our website, and you can look there for all of the information and any updates.
Yes, and also on that webpage we have a list of all the staff members by our district who are a point of person that you can talk to, and that website is actually on the slide right now. And the next question is a follow-up to the question about the commissioners. And this person asks, if an environmental justice issue comes to the commission before the training, do you believe commissioners will be prepared enough to examine the issue clearly from an environmental justice perspective?
I think so. I mean, we've already been having environmental justice projects, projects with an environmental justice element in them come before the commission, and I think we're all learning, but the team has been consulting with staff, and we've been including environmental justice sections in the staff reports to help inform commissioners.
Thanks, Nawaki. The next question is about ADUs, accessory dwelling units. And this person asks, does the environmental justice concept apply to accessory dwelling units, especially as taking analyses may need to be utilized to approve ADUs? He mentioned, and that's the end of that question. So Michael Ning from legal is going to answer some of that.
Yeah, this is Michael. I'm one of the staff attorneys for the commission. I don't know that we have looked at that specifically in terms of the intersection of our environmental justice policy and ADUs, but it's something that we can look into further. I guess what I will say is that in my understanding as far as accessory dwelling units is that recent changes in state law require that ADUs meeting certain specifications and standards as specified in state law or meeting locally implemented ordinances that are consistent with the state law must be approved by local governments, to address housing needs, local housing needs, which isn't to say that local governments can't regulate where ADUs occur or, development standards regarding those. So I guess to answer the question as best as I can, based on what we know, I think implementation of the environmental justice policy will have to be consistent with the statewide changes in ADU law, the recent changes in ADU law generally. And I'm not particularly aware that we have encountered a lot of takings concerns with respect to ADUs, primarily because ADUs are sort of an accessory use to a primary use. So I can't imagine that takings are implicated in a lot of situations involving ADUs, but again, that's something that we can look into. So.
Thank you, Michael. The next question asks, you mentioned during the webinar that Coastal Commission will investigate improper environmental justice claims. Are there any examples where the Coastal Commission investigated and found that environmental justice has been improperly used to advance an issue?
This is Nawaki. I can't think of any off the top of my head. As I said earlier, the policy is still relatively new, and we haven't had any yet, but that's certainly something that we would discuss with staff and our legal department if there are claims that are inappropriately made. One of the things that we have found is that there's a lot of people that actually don't know what environmental justice is. So we've had to kind of explain that over and over again because the term's a little bit confusing, I think, for some folks that aren't familiar with it. Does anybody else have anything you want to add?
Yeah, this is Michael again. I guess I would say in regards to the original question, just, the policy was adopted by the Commission at the March meeting. We have had a number of projects and hearings since that time where people have made environmental justice arguments either in support or in opposition to a proposed project. And just sort of as a general point, any sort of environmental justice claims that would, support approval or denial of any given project should be based on their consistency with Chapter 3 policies, which are the governing standard of review for commission actions. When the commission considers a project in the first instance, when a project's on appeal, the local LCP standards are the standard of review, and to the extent that an LCP has specific or robust or thorough policies or provisions regarding environmental justice, those may provide the standard and guide whether a project should be found consistent or not with the LCP. But those are sort of two situations worth distinguishing. And I think maybe this relates to the prior question about LCP guidance. I don't know how many LCPs are in place that have a lot of robust environmental justice policies at this moment, but that is obviously something that we are going to encourage local governments to do as they amend their LCPs, which I think is also something that's reflected in the policy as a commitment to implement our EJ policy.
I'd like to build on what Michael said. This is Sarah Christie, the Commission's Ledge Director up in Sacramento. And I mean, to put it, to shorthand it, the environmental justice policy is appropriately used to further Chapter 3 policies, not to override them. That wasn't the intent of the legislation, and it's not the effect of the statute. So, I mean, I think that it's important to keep an eye on the environmental part of environmental justice. The whole concept of environmental justice, not just the Commission's policy, but the whole concept of environmental justice was to ensure that environmental benefits are equally distributed and environmental burdens are not inequitably foisted upon one community or another. So that's not to say that jobs aren't important, or economic opportunities aren't important, or housing and business needs aren't important, but they're not environmental issues. So in the Coastal Act context, the intent of the policy is really to make sure that everyone shares equally in the benefits of the natural resources that are protected by the Coastal Act, that those natural resources aren't unnecessarily diminished or unattainable by certain communities or populations, but that the environmental benefits of the Coastal Act are equally accessible and equally attainable and distributed for all. So anything that is not in furtherance of that, I think, would be considered an inappropriate use of the environmental justice policy. We're certainly going to be, on the lookout for those kinds of arguments, but we're fairly new. The program's fairly new at this point, and fortunately, we haven't seen any examples of that to date.
Thank you, Sarah and Michael and Noaki. So next, I'm going to read two questions together. They both are related, they're related to this last question, so we can kind of continue to the discussion. The first question asks, how are policies being applied to Coastal Commission's review of development projects currently in the process by local governments? And related, the next question asks, what plans are envisioned to rein in abuses associated with affordable housing density bonus laws? Many coastal development applications exempt appeal to the Coastal Commission. This is being used by developers to bypass the Commission and also get waivers from local building codes. So both of these questions kind of focus in on the local government process and also the appeal process. So I'm going to hand it off to Michael first to answer
Sure. The first question, I think sort of was already kind of addressed in terms of just if something is being considered at the local level, say approved, and it gets appealed to us, you know, the standard of review would be the certified LCP policies. So to the extent that a specific particular LCP addresses environmental justice issues, that's going to be the standard of review and could be the basis if the commission finds substantial issue on an appeal and considers a project de novo. That could be a basis for the commission denying the project as inconsistent with the LCP or approving it as consistent with the LCP. So yeah, that's in the local government context, or projects being reviewed by the local government. Obviously, it's, like I said, going to be different if the commission is considering the project in the first instance. And as far as the density bonus law intersection, again, sort of how I was answering the ADU question, I'm not an expert on density bonus laws or the, actually sort of similar to the ADU law. It's my understanding that the density bonus law, which was also, I believe, recently amended, you know, provides certain incentives and I guess just exemptions from certain requirements to promote density for housing or projects that you know, account for more affordable housing. So it's my understanding that if developers comply with those provisions of the density bonus law, which allow for that density bonus, that essentially, you know, there's no discretion involved there, and they have to be allowed that density increase. There was a recent case, I believe Colnell Gardens versus the City of Los Angeles, where a court basically indicated that the Coastal Act supersedes or takes precedence over the density bonus law, and the legislature recently amended the density bonus law to clarify that you know, the two statutes should essentially be harmonized, that the Coastal Act does not, you know, supersede the state density bonus law. And I think as an agency, we're sort of working through how that plays out. But I do think I think, you know, amongst our planners and analysts, I think there is a feeling that those statutes can be harmonized and density bonuses can be, you know, recognized pursuant to state law, at the same time protecting significant coastal resources as required under the Coastal Act. So yeah, I think that answers that question.
Thank you, Michael. I'm going to read the next question. It is about OHV, and it asks, does the Coastal Act and environmental justice law take precedence over OHV statute? And Michael, could you also add what OHV means when you're answering the question?
Sure. I believe this person is talking about off-highway vehicles, which is a program under state parks. They have a division of off-highway motor vehicles, and they have a number of parks that are designated as OHV parks, which is just a classification of state park unit. There might be a couple in the coastal zone, maybe one up north, but certainly one that has been in the press a lot is Oceano Dunes, which has also, I think, there have been certain environmental justice arguments. It's a legal question. I don't know that we have an answer to that. I wouldn't say that our environmental justice policy takes precedence necessarily over state parks as law. Again, these are two state statutory regimes, and I think that we just have to look to see what sort of language is in the state parks law in regards to, if there's a conflict of laws with other laws, how do you resolve that? But I think as a more general statutory canon of construction, I think courts have generally said that when you have two, co-equal laws, or in this case, like two state laws in play, that they should try and be harmonized whenever possible before you get into whether one takes precedence over the other. And I don't think that as an agency we've necessarily evaluated how that interaction plays out, but we can look into that.
Thanks, Michael. I think you wanted to add something.
Yeah, so just on Friday of last week, State Parks came before the Coastal Commission and just gave an update on Oceano Dunes and the park. And there was quite a bit of discussion from the commissioners on EJ issues. So you may, our meetings are archived and recorded, so you may want to listen to that because there was some discussion about exactly what you've asked.
Thanks, Nowaki. The next question is asking, will harbor managers and staff be educated on this policy? Nowaki?
Well, as I said before, we, have a team of people, and we have been, meeting and discussing projects as they come before us. And we've been doing research and working on environmental justice sections, for these, particular projects in our staff reports. And we've also, in some cases gone out to these communities and spent the day or spent quite a bit of time to just listen to what folks are dealing with and the kind of environmental justice issues they're grappling with. And we are, as I said before, we've done some training already with the core group, and we're planning on more training that'll be more in depth later this year or the beginning of next year with our staff. So it's kind of a continuing, ongoing training and just, experience that we're getting with our new environmental justice policy. Does anybody else want to add to that?
I think we're good. Thanks, Nowaki. The next question is, most often equity is not equality. How do you address equity in this document?
I'm not sure if it's specifically in the policy, but I do recall in our first webinar, we sort of distinguished those concepts. So it might be specifically in the document, but
it comes up a lot in our internal discussions too, equity versus equality. And I think for folks that are listening, I guess, Michael, what's the best way to distinguish equity versus equality?
Well, I think an equitable outcome is one in which everyone is given an opportunity to reach the same, to reach a beneficial outcome, but it doesn't mean that everyone is treated as if they're all operating or coming from equal and exactly the same circumstances necessarily.
Yeah, I agree with Michael. I think we really want to make sure that, equity is something where we are recognizing that everyone's starting from different places. So when we are trying to think about environmental justice, it's recognizing that certain communities and populations have already been disproportionately burdened, have different capacities and access to resources. And so that is one example of where we're really recognizing that people are not starting from the same place. And, you know, we tried to embed that throughout our policy, and we hope that clarifies it some, and we're happy to talk a little bit more about it in a follow-up phone call.
Yeah, we also on page 19, there is at the back of the policy, there's a glossary of terms. And we do talk about the term equity because it is used in the policy. And here we say this policy uses the term equity as defined in the context of social and racial equity. And then there's a footnote where equity refers to the fairness of achieving outcomes for all groups, and no one factor such as race can be used to predict outcomes. So I hope that's helpful.
Thanks, Nowaki. The next question asks, how does a citizen represent their environmental justice concern without having to hire personal legal representation?
I guess I would say to that, if there is a particular project that you know, you were concerned about, you know, as a citizen, you know, you have the right and opportunity to make your voice heard at the local level, commenting on a project in support or in opposition to. You know, you can appeal projects to the commission potentially if it's within the appealable area. Make your views known for projects in front of the Coastal Commission, for which you have environmental justice concerns, and I think even sort of just more broadly, you know, opportunities to organize and to get together with like-minded people or research organizations who may be focused on those sorts of issues.
And Nowaki, did you want to add some more?
Yeah, I think that's a really great question. And that's really kind of what this policy is supposed to be used for. I mean, this policy is really a tool for the EJ communities. And if you really look at it and study it, you'll see that there are some openings and, you know, some areas that you can use to then, you know, come to the commission and, you know, ask us for you know, what you might need. We may not be able to just, you know, instantly hand it to you, but this is really what this is for. And this is really what our EJ team is for too, to try and kind of bridge that gap a little bit and help, you know, among other things. One of the things I've spent a lot of time doing is just sort of helping some of the EJ communities navigate the process, because it's not easy. I mean, it's difficult, you know, to know what to do when you get to commission, what you're allowed to do and how much time you have and all of these things. So, you know, that's really kind of what this is for. So, you know, if you have any issues, you know, feel free to reach out to us and you know, we will try and help as much as we can.
Thank you, Nowaki. So we have quite a few questions, and I want to be mindful of the time. We have about 10 more minutes left of our webinar time, and really quickly, I'm going to hand it off to Madeline Cavallari to answer, to talk a little bit about the intersection of sea level rise and environmental justice in our work, and then we'll get back to a few more questions before we wrap up the webinar.
Yeah, thanks, Sumi. Yeah, I just wanted to circle back and talk a little bit about what we've been doing in terms of sea level rise guidance and how it relates to the issue of environmental justice in our residential guidance, our draft residential guidance, which is not been adopted by the Commission yet, but is out for public review and up on our website. There we identified you know, environmental justice issues that stem from sea level rise impacts, talking about coastal squeeze, potential loss of beaches, and how shoreline protective devices as a sea level rise adaptation strategy could potentially lead to environmental justice issues. So we introduced the concept there. We're also thinking about it more as we develop our critical infrastructure adaptation guidance. That is a document that's not developed yet, not out for public review yet, but we are going to be putting together guidance for local governments for LCP development for how to address sea level rise adaptation for critical infrastructure. And, the critical infrastructure planning can have, I think, more implications for environmental justice issues. And so we're going to be thinking through those and developing more related to that as that unfolds. And then also I just wanted to say that also through our LCP grant program, we're asking local governments to address environmental justice issues through their vulnerability assessment and adaptation planning process. And so that's been going on at the local level. And as those issues are identified and addressed, I think we'll see more examples of local coastal programs coming forward and looking at these issues and how they relate to sea level rise adaptation planning and ensuring, again, going back to that equitable distribution of benefits and burdens, really wanting to look at what those sea level rise impacts are expected to be, what the adaptation strategies are, and how that affects all communities and environmental justice communities as well. Thanks.
Thank you, Madeline. And just a quick follow-up, we got a question asking about Coastal Commission grants. The person asked if we anticipate any grants coming in the future to help support environmental justice groups. And Noaki or Madeline or Sarah, if any of you would like to respond to that.
This is Sarah. We don't have any funding source or additional authority to start a new grant program for environmental justice grants. That would have to come from the legislature. I think we would probably welcome that. But I will say that our whale tail grant program, which is a fairly robust program, something in the nature of 75% of the grants that are awarded in that existing program go to underserved or go to projects that serve underserved communities or address issues related to environmental justice, particularly enhancing equity around access for inland communities or communities that face barriers to getting to the coast, even if they are approximately located to the coast, they have difficulty getting there. So there's no new grant program in the works, but I would urge anyone who's interested in pursuing an environmental justice related coastal grant to look to our whale tail grant program, and all of the guidelines, timelines, and deadlines for that are available and updated regularly on our website. So I hope that's helpful.
Also, this is Madeline, and related to our LCP grant program, we provide funding to local governments for LCP planning. There is an opportunity for local governments to potentially pass through funds to other agencies if it made sense within kind of an LCP planning project. And so it might make sense also to check in with any applicable local governments about whether there might be an opportunity to partner on some kind of planning aspect related to, future LCP development needs in that jurisdiction.
Thank you, Madeline and Sarah. So we're getting very close to the end of our time. I know we haven't been able to answer everyone's questions. I'm going to try and group 3 questions together that have to do with regards to enforcement and rezoning and how the environmental justice policy relates. And we'll answer that and wrap up question and answer. Anyone else's questions who we didn't answer, we will follow up with you individually. On our end, we can actually see the question asker, so we will personally follow up with you with answers. And so to wrap up, our final question is going to touch on a few different things. So one of the questions was asking about ocean-dependent zoned areas within the coastal zone that are being rezoned and granted conditional use permits. And, some of these areas are impacting access for recreational and commercial fishing opportunities. And the question asks, will the Coastal Commission environmental justice policy have any teeth to supersede local municipal governments? And kind of related to that, we had another question just about asking, how, if there is an issue that comes up, how can you be in contact, or if you want to appeal something? And so I'm going to hand it back to Michael to answer that question about zoning codes at the local level and how the Coastal Commission, our policies and our environmental justice policy apply to those.
Right. For the first part of the question about areas that are being rezoned and CUPs being granted, maybe the question asker should reach out to us or to the local district staff to provide a little more clarity. I think there's maybe some mixture of terms going on here, but essentially, if a local government has a LCP in place, any rezoning, should be updated as LCP amendment, and any, concerns that one has about CDPs or coastal development permits being granted that are impacting access and recreation should be referred to the local district office for potential enforcement action or just investigation to see whether there is any concerns about violations of the Coastal Act. And then the second part about hearing an appeal or grievance with regard to zoning codes, we only have appeal jurisdiction with respect to local governments for their portions that have, within the coastal zone. So again, to the extent that there is a violation of an LCP, the question asker should reach out to our district staff or enforcement staff to investigate. Where there are not LCPs in place, any development, which is defined under the Coastal Act, requires a coastal development permit from the commission. So if you think that is happening as well, unpermitted development, again, feel free to reach out to the local district staff nearest to you, and our enforcement and permitting staff can investigate to see whether there's any Coastal Act compliance issues.
Thank you, Michael. And I just want to echo what Michael was saying, that if any time you have a question, even if you're not sure if it's falling under the coastal zone or if it relates to the Coastal Act and our environmental justice work, or we're happy to answer any questions, you can contact us at environmentaljustice@coastal.ca.gov, and we are checking that email regularly. You can also contact any of our district offices or look on our website for a list of staff members by our districts who are both working in our planning work and also coordinating with our environmental justice team. And with that, I'm going to wrap up question and answer. We will be posting a recording of the webinar and sharing it with everyone who participated, and we will also be posting it on our website. Thank you so much for participating. And before I sign off, Milwaukee, Sarah, Madeline, and Michael, thank you so much for joining us. And do you guys have any other wrapping up final thoughts?
If you have any questions, just reach out. We're always happy to help, and we're here.
Thank you, everyone.